He entered halfway into the shoulder and then jerked back into the lane. After previously having just gone through a green light. So there's no indication that he's allowing a vehicle to pass or anything like that. He went through a green light, entered the shoulder, and then jerked back.
So by your theory then, any single person that ever drives a mere nanosecond to the right of an improved shoulder is now violating this offense, this transportation code. This law can't be like that. Good morning, Mr. Allen. Charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Hey, senor, hat off. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
Everything starts with one unusual movement on the road. The officer says the defendant drove through a green light like any other driver, but immediately after crossing the intersection, his truck suddenly drifted halfway onto the shoulder. Not a slight wobble, not a tiny adjustment, halfway onto the shoulder. And then just as quickly, he jerked the vehicle back into the lane. No signal, no justification, no visible reason. And this strange moment becomes the spark that leads to the entire legal battle over whether this was simply a harmless mistake or a sign of impaired driving.
And the defendant's motor vehicle proceeded, and the defendant's vehicle immediately drifted approximately halfway onto the shoulder with other motor vehicles around it before the driver jerked back into the lane. Traffic stop was then initiated, and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed slurred speech, bloodshot eyes, unsteadiness on feet, and an odor of an alcoholic beverage. The defendant admitted to consuming one alcoholic beverage, and standard sobriety tests were administered. HGN 6 out of 6. The walk and turn on one leg stand could not be performed due to the defendant complaining of leg pain. The defendant was read the DIC and consented to breath. The result was 0.192. However, the defendant was unable to provide a second sample and consented to a blood draw.
Mr. Allen, I'm going to find that there's probable cause to go forward with your case. Does he have a license?
It's possible, Your Honor.
All right. How many prior DWIs does he have?
He has one prior, Your Honor.
One? Okay. Mr. Allen, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs.
When the officer stops him, the symptoms start lining up one by one. Slurred speech. Bloodshot eyes. Unsteady feet. The smell of alcohol hanging in the air. The defendant admits he had one drink, the classic line everyone gives, and then the sobriety tests begin. HGN? 6 out of 6 clues. Walk and turn? Not completed. One leg stand? Refused because of leg pain. Every sign, every action starts stacking up. And when the breath test shows 0.192, more than twice the legal limit, the situation shifts from a simple stop to a serious second offense DWI case.
Drugs are unprescribed controlled medication. You have a valid license. You cannot drive unless you also have valid liability insurance in your name, and I'm now placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. Do you understand? I'm sending word and notice to DPS so that every police officer in the state is going to know if you get pulled over and you're driving a vehicle that doesn't have an interlock, they're going to arrest you on the spot. Do you understand? I see that you have a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with Mr. Stewart, and he will tell you when you have to come back to court. You don't have to waste your time coming back here, but you must stay in touch with counsel, and he'll tell you when you have to come back. You understand?
So I need to wait for him now?
We're going to have you wait for him now, but after today, I'm going to waive your appearance so you don't have to waste your time. We'll just have you work and do your life while we get evidence.
Inside the courtroom, the judge lays it out clearly and firmly. Probable cause is found. The bond conditions are set. The defendant is told he cannot consume alcohol, cannot drive without insurance, and cannot operate any vehicle that does not have an ignition interlock installed. The warning is sharp: if you're caught driving a vehicle without an interlock, I will revoke your bond and put you in jail. The judge even notifies DPS so every officer in the state can verify it. The courtroom tone is strict. This is not a warning. This is a final line.
He gets evidence to work the case up.
wait for him.
Right. I'm going to have you sign a reset. I'll have you meet with Felicia for bond conditions, and we'll just have you waiting back for Mr. Stewart to show. Okay? Please. Ready?
Yes.
Come on in.
Good morning, Your Honor.
Hey, how are you? Mr. Stewart, what's new?
Sir, how was your New Year?
Great. We did PC on your case.
Okay.
We just did stand up. What's your guy's name?
My last name is Alan, Your Honor. I would like to make an argument on PC. I don't know whether...
Absolutely. I'm always ready to hear it. So, refresh my memory. What happened?
So in Alan's case, it was where the officer came to a stop behind the defendant's vehicle and the light turned green. The defendant,
But he had expired registration, right?
No, Your Honor. In this case, the defendant's vehicle proceeded through the green light and immediately drifted approximately halfway onto the shoulder with other vehicles around it and then jerked back into the lane.
Were there any other vehicles around when this happened?
Yes, the officer explicitly wrote there are other vehicles.
And then comes the argument, the part where the whole case becomes a legal chess match. The defense lawyer steps in and challenges the very foundation of the stop. His point is simple: drifting onto a shoulder is not automatically a crime. Texas law allows 9 different reasons why a vehicle can legally be in the shoulder. And unless the officer clearly articulates danger or unsafe movement, the stop doesn't hold up. Where's the danger, he asks. Where's the threat to other drivers? Where's the unsafe element? His claim is that the officer wrote too little, assumed too much, and left too many details vague.
Around the vehicle before the driver jerked back to the lane. So he went into the shoulder and there were other vehicles.
Go ahead.
Yes, sir. My argument is, Your Honor, that, as far as what's actually alleged, says the light turned green and along with several other vehicles proceeded, which obviously is in compliance with the law. The only argument that the state has made here, elucidated, is that they observed a Silverado drift into the shoulder with other vehicles around it. If he's drifting into the shoulder, that's not endangering any other vehicle. That's not an allegation of the safety of anybody else out there on the roadway. The shoulder is away from any other vehicles. Maybe he's doing this in an abundance of caution. There's no indication that it was dangerous or endangered any other vehicle, anything like that within the allegations here. Furthermore, there's numerous reasons why a vehicle is 100% legally allowed to drive in the right-hand shoulder of a vehicle. I think there's 9 reasons in the state of Texas why a vehicle is allowed.
The prosecution fires back, arguing that the presence of other vehicles around is enough to justify concern, especially at midnight. They cite case law, mention Hardin, Martinez, Lamming, all the decisions that say weaving with traffic around you creates potential danger. But then the judge pushes back. Where exactly were those other cars? In front? Behind? Next to him? The officer's report only says other vehicles, nothing more. Too vague. Too broad. Not enough detail. And that's where the whole debate hangs, on whether this one-shoulder drift and quick jerk back was unsafe enough to justify the stop, or whether this was a legally weak, insufficient reason that should never have led to an arrest.